It's to spare.
Hey, John.
And it's nerve.
Good to see you, man.
I physically hurt after. Been tubing it forever. Used to
That's the one thing we didn't do. What we did 2 weeks ago. went through Rogers Park,
Are we ready?
up against
Are you ready?
Shut our traps.
Possible.
Okay, let's call to order a meeting of the Board of Adjustments for August 22nd, 2018. Welcome, everyone. We have a roll call, please. Kim?
Chairman Elliott,
Here.
Mr. Obowski,
Here.
Mr. Boris,
Yeah.
Mr. Eisner,
Here.
Ms. Turner,
Present.
Mr. Glenzer.
Here.
Okay, thank you. Let's be sure and silence our cell phones and whatever other electronic equipment we have. When you come to the podium, please state your name and address if you would. And we have 2 items on the agenda. And I wonder if it's possible if the applicant is here for the second one on Riverside Drive. Are you here? Would the board be objectionable if we took them out of order and let this one go first? Is that okay? I foresee that the sidewalk variance is going to take a little more time, and this one has a staff recommendation for approval. Okay, so we'll do that. We'll take this application 1881 first and then 1875 second. All right, let's begin with our quasi-judicial announcement from legal counsel, please, Mr. President.
This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it is not the board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates the applicant has met the criteria established in the Code of Ordinances, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates the applicant has failed to meet the criteria established in the Code of Ordinances, then the board is required by law to find against the applicant. Are there any members of the board tonight wishing to disclose any ex parte communication or conflicts of interest? Yes, sir.
I do. I got a call from my ex-next door neighbor. So he was kind of concerned about the voting on the board. So I spoke to him on how this board works and that we make our decisions on evidence that's brought upon us, and we do findings of fact. And that's what I explained to him.
Did any information that you received will influence your vote one way or the other?
No.
Okay, thank you very much. Anyone else from the board wishing to disclose any ex parte communication or conflicts of interest? Okay. All members of the audience or anyone that was going to be speaking tonight, they could please stand and raise their right hand to be sworn in. Do you swear or affirm the testimony you're about to give tonight is the truth, the whole truth, and nothing but the truth?
I do.
So sworn.
Okay, then, we're ready to start. Let's begin with application 1881, 848 Riverside Drive, across from the tennis courts for our vast television audience to be aware of. And let's begin with our staff report, please, Mr. Cerna.
Yes, Louis Cerna presenting staff comments. This request is for a 1-foot 8-inch reduction of the total side setback requirements for single-family residence. The property is 848 Riverside Drive. The property is zoned single-family residential R100. The applicant is requesting a variance from the total side setback requirement. The side yard setback on the principal structures, the current setbacks are 11.6 feet on the north side and 11.8 feet on the south side for a total of 23.4 feet. According to the R1 district standards, they are required to have a total of 25 feet. There is a sketch in your packet that shows the area of the existing structure on which they would wish to expand. Our findings on this is that the house was constructed in 1974 prior to the current zoning requirements. The lot itself was also created prior to that time. They were legally built, and the current lot does not meet the minimum lot width requirements of R100 of 75 feet, so that is a factor in making our determination. Our findings of fact, based on the criteria, are contained in your staff report. I won't go through them in detail unless you have any specific questions, but we did find that this request does meet the criteria for findings of approval, and our recommendation, therefore, is for a recommendation of approval with a single condition that the variance shall expire 2 years from the date of approval by the Board of Adjustment.
Thank you, sir. All right, let's hear from the applicant, please, if you would.
Good
State
evening.
your
My
name.
name is Anthony Zeronius. I live on 848.
I'm not sure the
Riverside.
mic is, try the other mic, make sure it's picking up your voice.
Can you hear me now? Better?
Oh, yes, that's good.
My name is Anthony Zeronius. I live on 848 Riverside Drive. We are planning to not reconstruct, but to add on a master suite to the north side of our home. We're not going to build. We're going to build to the existing structure of the house. So the new addition will meet the existing structure of the house. It will not surpass the old variances of the current structure.
Thank you. Anything else from you? Okay, then let's hear any questions from the board. My left, or ready for a motion?
Chair, do you want to see if anyone else from the
Oh, I'm
audience?
sorry. Is anybody in the audience on this item? I don't see anybody. Okay, thank you. Ready for a motion?
Motion to approve?
Any discussion? Okay, let's have a roll call, please, Ms. Yothers.
Ms. Turner,
Approve.
Mr. Eisner,
Approve?
Mr. Burris,
Approve.
Mr. Rabowski,
Yes.
Mr. Elliott.
Yes. Thank you.
Thank you very much.
You may go. All right, the second item then is application 1875. It's a waiver of requirement to construct a sidewalk on Innes Drive. This is the section of Innes Drive just recently started construction. And let's hear from our staff, please.
Yes. This application is to authorize a waiver from the sidewalk construction requirements of Section 132 of the Comprehensive Zoning and Land Development Code. The property is the eastern 287 feet of Innes Drive. The subject property consists of 8 single-family residential lots approved by the city under 2 separate replats. The subdivision contains a private roadway that dead ends in the Spring Bayou that serves as the access to the subdivision. The approved replat identified the roadway as an ingress, egress, sidewalk, drainage, and utility easement. The roadway and other infrastructure serving the 8 lots were constructed, and the replat was accepted by the city. However, the developer never constructed the sidewalks for the subdivision, nor did the developer request a sidewalk waiver as suggested by the Technical Review Committee in their meeting of July 9, 2015. In order to comply with Section 132, the construction of the sidewalks in front of each lot is now the responsibility of the individual owners as a condition of certificates of occupancy for the proposed houses to be built on the individual lots. The 7 owners of the lots in the subdivision have requested a waiver of the sidewalk construction requirements. The applicant has provided a narrative asserting that it is unfair to require the residents of the subdivision to construct the sidewalk because the community is private. It is a major liability for all property owners, and it is unfair for COs because COs have been previously granted for some of the lots. The Section 131 of the code requires that private streets comply with the same minimum criteria of public streets, which would require the subdivision. We would note that the developer was made aware of the sidewalk waiver process prior to the construction of the Ennis Point subdivision. At that time, no homes had been constructed and no COs had been issued. I'll go through our findings and the criteria on this one because it's a little different than most variances. These are specific to sidewalk waivers. In accordance with 132.01B, the request has to meet both of the following criteria. Number one is the need for the requested variance arises out of the physical surroundings, shape, topographic conditions, or other physical or environmental conditions that are unique to the specific property involved. And our finding is the subject property is a private subdivision located on a peninsula that extends into Spring Bayou. As such, it does not serve as public access to the water or other destinations. However, the sidewalk would serve the 8 lots within the subdivision and connect to existing and future sidewalks in the neighborhood. The second condition is that, or the second criteria is the conditions or specific circumstances peculiar to the property have not been self-created or have resulted from actions by the applicant or with prior knowledge or approval of the applicant. And our finding on this is that the location and configuration of the property are directly the results of the actions by the developer, who is also the applicant and contractor. The lack of sidewalk installation in this case is a result of action by the applicant. So our finding is that the request does not meet both of the requirements as required by Section 132.01B. Further, their criteria contained in 132.01C, the application has to meet one or more of the following conditions. And those are that the existing right-of-way is of insufficient width to allow installation of a sidewalk. And our finding is that the existing right-of-way is of sufficient width to accommodate a sidewalk. A sidewalk was identified on the approved replats, as we indicated. The second criteria is that the existing right-of-way is unimproved or not paved, and the construction of the street is not included in the responsible jurisdiction's 5-year capital improvement plan. In this case, that is not applicable because the existing right-of-way is paved, so that criteria is not met. The third criteria is that the strict application of the requirements would be technically impractical in terms of engineering design due to existing natural conditions related to topography or the environment. And our finding is that criteria is not met because the construction of the sidewalk would not pose any unusual engineering design challenges. And fourth, the Board of Adjustment shall not consider the non-presence of other sidewalks in the neighborhood as justification to grant the waiver. The issue is not being offered as justification of the waiver. In addition, there are sidewalks in the neighborhood. So our finding is that the application does not meet any of the 4 criteria of Section 132.01C. And based on these findings, staff is recommending denial of the requested waiver.
Thank you. Any questions from the board of the staff?
I do. So are you saying that if the criteria is met on any of these 4, it does not have to meet the first 2?
No, my reading of that is that it has to meet both of the first 2 and one or more of 1 through of the second floor.
Just looking for clarification. Thank you.
Legal lead.
Yes.
I have a question for the staff. This is a waiver request, and the wording in the ordinance in Part 3, Number 1, requested variance. You see that? That word is wrong, correct? There should be a waiver in the Code of Ordinances?
Yes, it should be for, in this case, a review criteria for a waiver. That's correct.
Okay, the need for a requested waiver arises out of the, right? Okay, you'll maybe make the correction at some point in the code. All right, I have a lot of other comments, but if we are finished with the staff questions from the board, then let's have the applicants proceed. If you've not been sworn, please let us know. Anybody here come in and has not taken the oath, you can do so at this time or when you come up.
Thank you.
Thank you.
Thank you.
And the second group is full-size copies of some of the plans. I only brought one set, so I'll leave them with the chairman, and then you can open them up and look at them at your leisure. I do have the reduced versions in the package.
Cindy, you want to identify yourself?
And I apologize, I started speaking without introducing myself. My name is Cindy Terrapini. I'm Vice President of Planning for Florida Design Consultants. And this evening, I represent one of the property owners within Innes Point, Anthony and Roxanne Marteri. I'm not the applicant. He is here as well, and he will speak also. But I do represent one of the property owners. They own lots 3 and 4, which is the 2 vacant lots at the east end of the property. My clients are planning to build a single-family home on the 2 lots. They're going to combine them for one property. And that's why I'm here tonight, is to speak in favor of the waiver. There's 2 major reasons why this waiver should be granted. The first reason that the waiver should be granted is that the only place to install the sidewalk is on private property. This section of Innes Drive is a private drive, individually owned by the property owners. They own to the center of the pavement. That's shown on the plat, which is, and I'll talk about all the documentation in a minute. It's also shown on the 2 maps that you have in your staff report. It clearly shows that the right-of-way stops at the west end of the property. And this Innes Drive has always been, according to my research, an ingress-egress easement and never public right-of-way. The city staff has indicated that sidewalks are required on both public and private streets per the code. However, Innes Drive is neither a public nor a private street. It is private property over which there is an access easement to allow those 8 property owners to go back and forth and the folks that they would invite to their homes. Therefore, the section of the code requiring a sidewalk is not applicable to Innes Drive, and that's why the waiver should be approved. The city does have private streets in the city, and you all are probably aware of them. Some that come to mind instantly are Point Alexis and Harbor Watch, but that is not what this situation is. Additionally, as is evident from the aerial, and I'm sure you're familiar with the site, this portion of Innes Drive dead ends at Spring Bayou. It provides access only to these 8 lots. It does not connect to any other street, and is not part of a street network. I'd like to point out that on page 3 of the staff report, in response to criteria number 2 and 3, the staff report incorrectly labels Innes Drive as an existing right-of-way. It is not a right-of-way. If the waiver is not granted, the sidewalk will be located on private property. The effect of putting a sidewalk on private property will be to invite the public onto this sidewalk, and it could be attractive because it leads down to Spring Bayou to the water, and it will create an enormous liability to each of these property owners. Who will have the liability if someone is injured on that sidewalk? It will not be the public. not be the city, because it is not a public right-of-way. It will be those 8 property owners. To require these homeowners to bear the burden of liability is not only unfair, but could also be considered a taking of private property without compensation. By that, I mean, if you have a public use, such as a sidewalk on private property, that is considered a taking without compensation. But if the city thinks the sidewalk is so necessary and so important to the overall city good, then I would encourage the city to obtain the adequate right-of-way either through purchasing or eminent domain and build the sidewalk themselves. That is always an option that the city has. The second major reason the waiver should be granted is that the city has granted approval of multiple applications for this project, and I'm going to go through each one of them. None of those approvals showed the installation of a sidewalk. Let me repeat that. None of those approvals showed the sidewalk. The Board of Commissioners approved the site plan and the final plat. The city staff approved construction plans, an estimate of improvements for construction, and the building permits for the 4 existing homes. None of these showed a sidewalk, and none of the plans showed the sidewalk, or was there a condition to add the sidewalk at a later date. To now require the 7 homeowners to install the sidewalks is an unfair and inordinate burden on these property owners because they have relied on the city's previous approvals. Now I'd like to go through each of the documents that shows what I have just confirmed to you, and are in the booklet that you have in front of you. So going back to the first reason that this is an easement, it is privately owned, and the road is on private property, not a right-of-way. If you'll turn to Exhibit 1, you will see the city approval. It's Resolution 2016-22, and that's a city resolution approving the final plat for Innes Point. And then right behind, and the staff recommended approval. That document is in there as well. And then you'll see the 2-page plat. And if you turn to the second page of the plat, you can clearly see that it is a 24-foot private ingress-egress easement, and there's a plat book referenced private road. There's also a utility easement, but that's not really relevant for tonight's meeting. Clearly, that is not a right-of-way, and this is what the City Commission approved, is this final plat. If the board had thought at the time that a right-of-way was needed instead of an easement, they had every right to require that, but they did not. I would also refer to the 2 maps in the city staff report that I mentioned earlier, again showing that the right-of-way stops at the west edge of the site. I don't think that that point is in dispute. It is also important to note that since Innes Drive is a private driveway, the owners have the right and they have intent to install a gate at the project's entrance on the west edge. Once that gate is installed, there is absolutely no purpose at all or no ability to use a sidewalk. The second major reason that I've suggested to you that this should be approved is that there are multiple city approvals without showing a sidewalk, and I'd like to walk through those. The city's process for a subdivision has 4 steps or 4 phases. The developer submitted and received approval for all 4 steps. So starting with the first one, site plan approval. You will turn to your Exhibit 2. You will see the resolution number 2015-28, which is the city's approval, City Board of Commissioners approval of the site plan. And then I also have in there for you the actual site plan. And Mr. Elliott, Mr. Chairman, Exhibit 2, there's a full-size version of Exhibit 2. If you'd like to take a look at it, there's also a full-size version of the plat that I handed the chairman earlier. You're welcome to take a look at those. On October 6, 2015, the Board of Commissioners approved the site plan. And if you look in the resolution, the first and second pages, there are 11 conditions related to that site plan. None of those relates to a sidewalk or says anything about adding a sidewalk at some future date. The second part of a subdivision approval is for the developer to submit construction drawings, which he did, and the city staff approved the construction plans and issued a building permit on March 1st, 2016. You'll refer to Exhibit 3. The first document in that exhibit is the approved building permit signed by the city staff. Then the second document, and there are 6 pages to it, is the site plan that was, the construction plans that were approved. Looks remarkably similar to the site plan, as you can imagine. This was approved by the city staff in 2016. Consistent with the site plan, the construction plans continue to show Innes Drive as a private drive, and an easement, and there are no sidewalks shown on the construction plan. The third step in a subdivision review by the city is for the developer to install the improvements. In some cases, the developer installs all the improvements and then does the final plat. But alternatively, the city does allow, and this developer decided to bond the improvements or provide a letter of credit so that he could go ahead and go to final plat. And if you'll turn to now to Exhibit 4, this includes the documents related to the improvements. So the process for that is a little more detailed, but I think it's important for y'all to see it as well. The first step in that improvement process is that the developer's contractor or the developer himself submits a cost estimate for the improvements. And those are the first 2 pages in Exhibit 4, at tab 4. Then the city reviews that cost estimate, compares them to the construction plans, compares them to their knowledge of costs for doing improvements, and either approves or denies it. The third page in that same exhibit, Exhibit 4, is a letter from Anthony Mastraccio, the Building Development Director, who approved the cost estimate and requested that the developer provide a letter of credit. The next 2 pages are the irrevocable letter of credit issued by Flagship Bank. So what this does, for any of you who may or may not be familiar, the bank is saying, we have a letter of credit. We are confirming that this money is available. For any reason the developer should not complete the improvements or complete them satisfactorily, the city has the ability, through this letter of credit, to draw on that money and use that money to complete those improvements. So the letter of credit was submitted to the city for the same amount as the cost estimates that the city staff had approved. Then what happened was the developer completed the improvements, and then he requested that the letter of credit be released back to him. Since the improvements were complete, there was no need any longer for a letter of credit or a financial guarantee. And the last page in Exhibit 4 is a memorandum from the Building Department and the Planning Department dated October 26, 2016, requesting the clerk to release the letter of credit. And if you'll read, this is really important. The improvements for the Innes Point subdivision have been accepted by the Building Development Department. So in other words, all the improvements are complete in the city's opinion, and the letter of credit can go back to the developer. There's a cost to a developer to have a letter of credit or a bond, so that's why it's important to the developer to get that back. It's almost like getting cash back. Mr. Elliott can explain it probably better than I. So anyway, on October 26, 2016, the city staff, the 2 departments that are most affected by this and responsible, the Building Department and the Planning Department, said, yes, he's finished the improvements, you can give him the letter of credit back. If you see at the very bottom of that page, Doug Matthews signed it on November 3rd, 2016, indicating that he had picked up the bond and he was in agreement with that. The last phase of a subdivision in the city's process is the approval of the final plat. So the developer finished his improvements. He submitted for a final plat, and the Board of Commissioners approved it on September 6, 2016. This is back in tab 1 that we talked about just a little bit ago. But again, the Board of Commissioners looked at that. Staff reviewed the subdivision plat. There was no mention of requiring right-of-way. It was accepted that the Innes Drive could remain as an ingress-egress easement and private property with that easement on top of it. And so they approved the final plat. So in summary of these issues, the developer followed each phase of the city requires process. He got approval for each phase of that process, either by the Board of Commissioners as appropriate or the city staff. None of the phases approvals required the installation of the sidewalk, and none of the plans showed a sidewalk to be installed or a condition to require it at some later date. That was because Innes Drive was private property. It was not a street or a right-of-way. The city had multiple opportunities to require it to be a right-of-way. They declined to do so, believing that there was no need, and this is my supposition, but it seems to me the reason they did that, there was only 8 lots, there was no need to require a right-of-way. The final thing I wanted to mention to you in terms of documents is Exhibit 5. There are 4 homes that exist in this subdivision. There are 8 lots total. There will eventually be 7 homes because my clients own 2 lots. So 4 of those lots have been built on, and the city has issued certificates of occupancy for those 4 homes. However, and this is at tab 5, you can read them as we talk, 2 of those houses have temporary or conditional COs requiring a sidewalk. Those are 77 Innes Drive, Mr. Bischoff, And 78 Innes Drive, Mr. Damalos. Mr. Bischoff, except for the developer, Mr. Bischoff has been in the property the longest since 2017. And he only found out about the lack of the sidewalks. He's here, he can tell you this himself. He only found out about the sidewalk requirement in 2018, way after he had already been CO'd. There's 2 lots also that have permanent COs and don't have any condition about a sidewalk, and those are 79 Innes Drive for the Sarukas family and 82 Innes Drive for the Matthews family. Now I want to talk a little bit about the criteria for issuing a waiver, and as you can imagine, I have a drastically different opinion than the staff on how the application complies with those waiver criteria. The code says the first 2 must be met. You have to meet both of them, and I believe we do meet both of them. First of all, the conditions that are unique to the site are these. Innes Drive is a private drive. It is located on private property. There is no right-of-way. It is not a public street or a private street. It is merely an easement over which people can travel, the owners of those houses and folks that they might invite in. Innes Drive dead ends at Spring Bayou and only provides access to the 8 lots. Installing a sidewalk open to the public on private land would indeed be a unique situation in the city, since throughout the city, sidewalks are routinely installed on public right-of-way. Examples of recently approved subdivisions with sidewalks in the public right-of-way are Tarpon Key on the north side of the river and Bayshore Heights. I think we all know that for any size subdivision, whether it's an 8-lot subdivision or a 30-lot subdivision, when a public right-of-way is dedicated, the sidewalk would be installed. The second criteria is that the special conditions are not unique or not created by the developer. Well, clearly, the fact that Innes Drive is a private drive and has been since 1998 was not created by the developer. He didn't even buy the property until substantially after that. The status as an easement is not the creation of the applicant, nor is the dead-end configuration of Innes Drive the creation of the developer. It's not his fault. That's just the way the land was laid out and the way the land was created. Since both of the first 2 criteria are met, the Land Development Code states the waiver must be granted. And then there are 4 additional criteria, and I agree with Mr. Cerna. My reading of the code is only one of those 4 must be met, and we do meet one of them. A couple of them, actually 3 of them, don't apply. Let me explain. The first criteria says that the waiver should be granted if the existing right-of-way is not wide enough for a sidewalk. There is no existing right-of-way. So that just doesn't even apply to us. It doesn't mean that we meet it or don't meet it. It just is irrelevant. The second criteria is if the existing right-of-way is unpaved, then you might get a sidewalk variance. Again, there is no existing right-of-way. This is not existing right-of-way. It's not any kind of right-of-way. Existing, proposed, it is privately owned property, distinctly different from right-of-way. The third criteria is that requiring the sidewalk would be technically impractical in terms of engineering design, and I believe that it would. And that is because to install these sidewalks over private property today, there has been landscaping installed, there have been irrigation systems installed, and certainly there have been underground utilities, sewer, water, reclaimed water, electric and cable. All of those services have been installed to the 4 houses that exist there today, as well as stub outs to the other lots. So clearly, technically, it will be difficult and impractical to install that sidewalk, and there's going to have to be a whole lot of surveying done to figure out where actually are the utilities to make sure that you don't impact those utilities and cut off somebody's sewer or water. So is it difficult? Yes. Is it technically impractical? Yes, it is, for those reasons. The fourth criteria is that you should not consider the lack of sidewalks in the area as a justification. We're not asking for that, so that's another one that doesn't apply. So of the 4, 3 of them are irrelevant and not applicable to our site. The third one, that it's technically difficult and impractical, we believe that it does meet that criteria. Just to summarize, as I stated in my introduction, there's 2 major reasons to approve this waiver, in addition to the fact that it complies with the waiver criteria. First of all, the only place to install the sidewalk is on private property. Again, if you require the sidewalk on private property, it will create a significant burden and liability for all those property owners if someone's injured on that sidewalk. Additionally, to require that public use on private property, a sidewalk is considered a public use. It's a taking of private property without compensation. It's clearly a violation of the Constitution. Again, if the city thinks sidewalks are that necessary on this small little subdivision, they have the opportunity to do that themselves. And I certainly am not aware of any city regulation that can require a property owner to allow the public to cross his own private property against his will. I think that's generally called trespassing. The second major reason to approve the waiver is that the project and the developer followed the city's process for subdivision and received every approval that was required. 2 of those approvals were by the Board of Commissioners. That's the site plan and the final plat. And then the staff approved the construction plans and building permits and the improvement issue that we've talked about. The city staff does not have the authority to override the Board of Commissioners' decisions on this matter and to now require the sidewalk, or, as I think might have happened, although I can't be sure, change their interpretation somehow to now say that we are subject to this requirement when clearly at the time the site plan and the plat, the construction drawings and the building permits were issued, the city believed that the sidewalk wasn't required. It's right and fair that these property owners can rely on the city's previous approvals, and that's why they've requested this waiver. Based on the facts and the evidence that I provided to you tonight, I believe that the application has met all the criteria for approval of a waiver. I would respectfully request your approval tonight. I'd be happy to answer any questions. I know I've provided a lot of information that you may not have seen before. Again, I'm happy to answer your questions, and I do thank you very much for your time.
Thank you very much, Mrs. Terrapini. I forgot to mention that there's full cross-examination. Anybody can cross-examine anybody from the staff or the applicants. I want to make sure we're aware of that. Also want to make sure we're aware we have an existing commissioner visiting with us today, Commissioner Carr. Thank you very much. And prior Commissioner Terrapini sitting back there. Thank you for coming to visit with us. Any questions from the board, first of all?
I do.
Yes, sir.
Thank you for your in-depth report. When I'm listening to you, making it sound to me that the developer did everything accordingly and the city approved of it. But in this paragraph, and let me read this to you, what it states, it says the developer was made aware of the sidewalk waiver process previous to the construction. And I can read the rest of the paragraph, so that kind of negates your explanation that it's, that the city accepted it the way it was. It also states here that the city staff erred in its not picking that up. So that also doesn't give anybody who's doing something, building something, the right to not put that in because there's been an error. So these are the 2 things that I see. Beside, there's another part that I would love for you to explain where it says, however, the developer never constructed sidewalks for the subdivision, nor did the developer request a sidewalk waiver as suggested by the Technical Review Committee on July 9th, 2015. And it says to refer to the minutes. Was the developer recommended by the Technical Committee? I don't know if you can answer that question.
Thank you, Mr. Eisner, for your questions. I can answer some of them. I did not represent the developer, and I wasn't part of the review process for these applications, so I can't testify to what the staff told the developer. If he, he can testify to that as he wishes. But I can testify to what it said, and I have the Technical Review Committee minutes from July 9th, 2015, when the site plan was reviewed, and this is, I quote, this is the only comment anywhere in the TRC minutes about sidewalks, and here's what it says. Sidewalk dash possible waiver to requirements. What does that mean? I have no idea what that means. Does that mean the staff might possibly require the waiver, or the applicant might possibly request it if he decides to, or does it mean that possibly the sidewalks are required, possibly they're not? I really don't know what that means. Every site plan that I've ever seen in the city, and this one included, has conditions attached to it. If the developer didn't show the sidewalk on the site plan, which we know that he didn't, because you have the site plan in front of you, they could have made it a condition of approval. They did not. You have that resolution in front of you. It was not included as a condition. If the staff felt that the sidewalk was required, then they should have made it a condition, either made it a condition or shown it on the site plan. Again, I'm coming to this as a forensic investigator, trying to figure out what happened in the past. And my supposition is that when they saw that it was private property and not a public street, not a private street, that the staff decision at the time was that the sidewalk was not required, because you only have to do a sidewalk if you're a public street or a private street. That's clearly what the code says, and I absolutely agree that that's what the code says. This driveway is neither. It is neither a public street nor a private street. It is private property. Those are totally different animals, streets and right-of-way and property. So clearly, that's my belief. I cannot prove that because there's no documents that show that, except to me, the document that shows that that's what they must have been thinking at the time, by they, I mean the staff, is that the site plan got approved with no sidewalk on the site plan and no condition to require it at some later date.
I have a question. I'm sorry.
Mr. Glenzer?
Mine's really loud,
I
isn't it?
wasn't,
Oh, I'm sorry. Go ahead.
I just wanted to follow up with two other things. You also mentioned about liability. But just plain given, everybody who owns sidewalk, owns a house, has liability. So, I understand you're saying that they shouldn't have the liability because they don't have the sidewalk, and putting the sidewalk would give them liability. But anybody walking on their property right now would have liability.
I agree. That is, when any property owner or homeowner or resident invite someone into your home and something happens in your home that's your fault, yeah, you have liability. Maybe your stairs haven't been fixed or, whatever it might be. That is distinctly different from a sidewalk. In a sidewalk, in a public right-of-way, if someone trips and falls on that sidewalk, the city is liable and the city carries insurance for exactly those kind of claims. If this sidewalk is required, it will be put on private property. It's not in a public right-of-way. The city will not insure it and pay out any claim if someone gets injured on that. That's the distinction I'm trying to make. It's totally one thing if what happens inside the home or on your property. We all understand that something could happen and you would be liable. I'm talking about what would happen on the sidewalk. On a public sidewalk, the city has a liability because they have the right-of-way, and they have the requirement to maintain the right-of-way, the road, the curbs, all of those things in the right-of-way. So if something happens, the city is liable.
And
If
for
you don't, I'm sorry.
Go ahead.
If you don't allow the waiver and you require the sidewalk, it will be on private property, and that will be an additional burden and an additional liability that the homeowners will have.
If we could seek clarification, because I do understand, we are, as a homeowner, you own, that is private property. That is a public sidewalk on private property.
No, ma'am, it cannot be, how can you have a public sidewalk on private property? You cannot.
That's what I'm asking for the clarification from our council on because we're talking about right-of-way versus personal property. This can't be the only personal property where there is a sidewalk on it.
Correct.
So how is this different? How is a sidewalk on these lots different than a sidewalk on any other lot?
I'm not going to opine on the conflicting reports, but what I can opine is that there are sidewalks on private property that are maintained by cities and
Where the sidewalk would, so if a sidewalk were to be constructed on these
then that's when
7 to 8 lots, the liability lies where?
I can't answer that question.
Could I stick
I think it's pretty clear. The liability goes with whoever owns the property. The people who own the property where that sidewalk will be constructed are my clients and the other owners of those lots. The city doesn't own anything there. They don't have any right-of-way there. They don't have any ownership. So they can't possibly, how can someone who doesn't own it be liable? I mean, that's my opinion. I'm not an attorney. I'm not trying to supersede your attorney's advice, but I'm just saying pretty clearly how it works.
That's not what I'm saying. I don't want to give the answer of what you are trying to decide tonight, because you're getting two conflicting reports of if this is an easement, right-of-way, private property. I'm saying, correct, the person that would be sued would be the private property owner.
Okay, which is sounding different than what Ms. Terrapini is reporting.
There are two questions you're asking me, whether you know it or not. You're
Okay.
asking me, I'm not going to opine on where the property is or whose property it is.
Sure.
If it is private property and someone is hurt on private property, whether there's a sidewalk on it, whether there's a house on it, whether there's a vacant lot, if it is private property, the private property owner would be liable, or potentially.
Correct.
Yes.
And and just to close the loop on that, if you would, y'all certainly have the ability to do this as you do this at every one of your meetings. Take a look at the plat, the Ennis Point plat, which is Exhibit 1, and see that the property lines for each lot extend to the center of that easement. So there's no public property that runs through the middle of Innes Point. It is all private property. It's an Exhibit 1 is the Innes Point subdivision plat. No, Exhibit 1.
Yes, ma'am, this is Exhibit 1.
Exhibit 1, okay.
Yes, ma'am. So, and I am seeing here in Exhibit 1, it does state this 21-inch, prescription's bad, 21-inch ingress, egress, sidewalk, drainage, and utility easement.
And there also is the ingress egress easement that was the original easement, and I know this is maybe more than you want to know, is the 24-foot, it's in about the center of the plat. It says 24-foot private ingress egress easement from Plat Book 125, page 76. That was the original 24-foot easement that's been there since at least 1998. At some point when this plat was, as part of this plat, the 21-foot ingress, egress, sidewalk, drainage, and utility easement was added so that the developer could install the utilities within that portion of the property. So that is, and of course, drainage facilities in that area as well.
But it is labeled sidewalk.
It's an easement, which does not mean does not require you to install a sidewalk, does not require you to install utilities. It says that an easement grants the right for ingress and egress, the right to put in utilities, and the right to put in a sidewalk. It does not require a sidewalk. Big distinction, very important distinction.
Okay. All right, thank you for that clarification. So if if the city has a right to have a sidewalk there, then does that mean the city assumes a liability for what happens on that city sidewalk? Not talking about the private property, home, yard, stairs, so on, the sidewalk itself.
If you look on the face of the Innes Point plat, on the dedication portion, it's the third paragraph down under dedication. The easement is dedicated to the owners of the plat. It is not dedicated to the city. The city has no interest whatsoever in that easement. Okay. For example, the utilities that are in the easement that serve each of those 8 lots are the obligation of each property owner. If there's a problem with that sewer connection or water connection in the easement, in that driveway, each individual property owner has to repair it. Once the sewer line goes off the site and goes to the west out of the property, that's when the city's obligation would pick up. So again, the dedication, actually I guess it's the 4th paragraph down, is dedicated to the owners of the lots.
So I hate to harp on the liability, but I understand that is a, obviously major concern. But you did state that this is going to be a gated road, so it is private property, it will be gated to prevent access. So doesn't that help cover the liability? I'm just throwing that out there.
It might, but at this point in time, it is not gated, and we've been advised by the city staff that to gate it, since the gate wasn't shown on the site plan, we have to go back through the site plan process and amend the site plan. So if you take that to its logical conclusion, since the sidewalk wasn't shown on there, we would have to go back somehow through the site plan process. So I have that in writing from Mr. Weiler that that's what we would have to do to add a gate. I'm sure there's going to be requirements from the fire department about how many cars have to stack up and all those other things. We would like to put in a gate. I hope to help the developer and my client put in a gate, but it is not there today. It could help if it were installed, but it's not installed today.
Yeah, perhaps if I could clarify, I guess, staff's position on the street issue is this is a private street, whether or not ownership is to the center line or it's dedicated to a homeowners association that would own a private street. And with a public street, the public assumes liability. With a private street, whoever owns the street, whether it's the individual owner or a homeowners association, assumes liability. The code requires the private streets be built to public construction standards, and that, in staff's opinion, would include the sidewalk. A lot of what the city's review on this is to make sure that the street is built to public standards. So there's a lot of construction review, and despite the fact that the property lines are to the center line of this street, it is indeed, as defined by code, a street, and that's in the definition section of the code. And that's staff's position is that despite ownership, who owns the street, it is private. The code is clear that private streets must be built to public construction standards. So,
If I could
and that
res-
would include the sidewalk.
Can I just respond to that, Mr. Chairman, then I'll sit down. A street and your private property where your house sits are two mutually exclusive things. My property doesn't go into the middle of Spring Boulevard. Your property doesn't go into the middle of the street. Most of you, I'm guessing, I don't know where all of you live. If you live on a public street, your ownership doesn't go into the middle of that street. There's a street which is distinct and separate from private property. That's a distinction. I must respectfully disagree with Mr. Cerna. It is not a private street. It is a driveway, and it is privately owned property. And there is an easement that goes over the top of it. But again, an easement and a street and a street or a street right-of-way are two distinctly different things. And Mr. Elliott's an attorney. He can explain it to you probably better than I could. An easement is different from a right-of-way. An easement means the property owner still owns the land underneath, which is the case in this application. I thank you for your patience.
Okay, don't go away.
Oh,
Actually,
okay.
yeah,
Sorry,
I
Mr.
still had a
Glanzer?
question.
Yeah.
This is really an interesting case, by the way. Thank you for the details. You've mentioned quite a few times that back on Resolution 2015-28, that the developer met all the conditions. You just summarily said, we met all the conditions, and I'm looking for a little bit of clarification on condition number 1 that says the developer is responsible for acquiring all other jurisdictional permits and/or approvals and for meeting the minimum criteria of the Land Development Code.
Mm-hmm.
It doesn't say sidewalk. It says all other. And I'm curious how we've gotten to this point 3 years later where it wasn't that it doesn't say that the staff is responsible for that or the staff can't make an error. It says the developer is responsible. So I kind of believe the way I read that, and I'd look for some clarification maybe from council or staff, but it kind of sounds like that's included. That's part of all the other minimum land development code. Can you explain how that doesn't cover sidewalks or anything else required?
Sure. Thank you for your question, Mr. Glinzer. The developer did work, the other jurisdictional permits is, I believe is referring to SwiftMud or FDOT or any other non-city agencies. He has an exemption from SwiftMud. What I would say to you is that, first of all, I've seen this condition. It's kind of a blanket condition the city puts in all their site plan approvals. Where that condition is then reviewed by the staff is in the next 2 levels of review process, which is in construction plans and building permits. So again, the city has a responsibility. You just can't say, here, take this whole land development code and be sure you do everything. Yes, the developer has some obligation, but also when he submits a set of plans, construction plans and building permits, and the city approves them, then you must only draw the conclusion that the city approved it because it met everything in that land development code. The city knows that code better than anybody. So, I mean, I read it a lot, but I certainly don't know it as well as the folks that deal with it every day, like Mr. Cerna or Ms. Erweiler. So, yes, this is a general statement that he must comply with all that, but the city reviewed this project 2 more times for the specific compliance with the land development code and approved it without a sidewalk.
And I hear you. However, I kind of link that back to there must have been, based on even other statements, and Mr. Eisner brought it up, there was some talk back in 2015 about sidewalks. I wasn't there. It was part of the minutes, but there was talk about sidewalks. There was talk about conditions. It wasn't like it was a new concept that just came up in 2018. It's been out there for a while in some way, shape, or form. Mm-hmm. And I wasn't there, and I don't know if it was any of those meetings were videotaped that we could see what was actually.
I don't think they videotaped the TRC meeting.
I don't know, but it just seems like you said, the city knows the code better than anybody. I know that if I'm driving 80 miles an hour in a 70-mile-an-hour zone and I didn't know that it was 70, my ignorance of the law doesn't exempt me from the law. I still have to go 70. I can't go 80. I can't do things that I'm not supposed to do. I'm pretty sure that's a pretty general.
And I totally.
And I'm not
agree.
saying that the homeowners, I'm saying I go back to the developer. And at this point, I'm trying to forget who pays for anything. Whether it's homeowners, developer, city, I'm trying to forget about that in my own head and wrap my arms around the bottom line. Should there be sidewalks here?
Could I interrupt?
Can I, Mr. Elliott, could I respond to that question if you don't mind?
I'd like to have everybody speak first, and then we'll get into the discussion of what should happen.
Okay.
Good idea.
I think we're just going back, just plowing new ground if we could. I've got a lot of things I want to say. I'm going to hold off. Maybe I shouldn't say what I want to say, but maybe I will at the end. But let's ask anybody else in the audience who wishes to speak on this item to please come up to the podium. Identify yourself.
Good evening. Doug Matthews. I live at 82 Innis Drive. I am the developer and builder of the first 4 homes that are on this street, or easement, as the case would be. My house was the first house built. I CO'd it. It was CO'd in December of 2015 without a sidewalk. I'm aware of the application, or the note for application for variance of that said sidewalk. There was a conversation I had with Anthony Mastrasio, who was at that time head of the building department, engineering and planning and zoning. And the conversation was, again, putting sidewalks on the front of this house, on the front of these properties, would offer a liability to the homeowners that nobody really wants. Conversation was to create sidewalks, or by design, or to create community, at least in this particular area. And what essentially the verbal approval from Mr. Mastrasio was to take the sidewalks from the front of the property and put them on the rear of the property, where this entire peninsula is all waterfront property. We in turn installed a 6-foot wide concrete boardwalk around the entire perimeter of the 8 properties. That, from what I can understand, basically satisfied the requirement, and that's why we ended up going to final plat and such, as Ms. Terrapini explained.
But this was a verbal agreement.
Yes, ma'am.
That?
Yes, ma'am.
That's your statement?
Yeah, that's my statement.
Yes, sir.
Did you, after you built your home and had your CO, did you then first apply for replatting the whole area?
No, the replat for Innis Point is actually for the property on the north side of Innis Drive, or the north side of that easement. My property was already subdivided, I want to say, I think in 2008, and it was it's a subdivision known as Tarpon Estates. So again, that situation there, we have 8 lots that essentially are assigned to 3 different entities. We have the north side of the Innis Drive easement is Innis Point, and then the south side, there's 3 lots there that are noted as Tarpon Estates, and then on the south side, furthest west lot is owned by a Dr. Root, or the Root Family Trust, I believe. And that property has been owned by Dr. Root since, I believe, 2003.
So we should only be speaking about then the first 4.
Possibly, yes. Yeah, we should only probably be talking about the north side of the street, or the easement, or whatever we're going to call it.
So if we're speaking about the first 4, my question to you would be, when the technical review committee on July 9th explained the need to set up a variance so that you didn't need a sidewalk, why was that not followed through?
Again, that was a conversation that Anthony Mastrasio and I had regarding that, and I believed, in my mind, was resolved by putting a sidewalk on the rear of the properties that connected all of these properties together to form a community.
But there's no documentation of that.
I understand. Yes, sir.
How many homes were built before 8/23/16?
There were my home at 82 Innes Drive and Mr. Bischoff's at 79 Innes Drive,
So
or
the-
77 Innes Drive.
So the other 6 were built after 8/23/16, correct?
Yes.
Okay. On Exhibit 1, on this great booklet that was presented to us, it has 2 pages.
Yes.
On page 2, on the lower right, it says ingress, egress, sidewalk, drainage, and utility easement. It says it right in the bottom here. So the other 6 homes were built after this was recorded with the city or the county, wherever the recording was done. Why this wasn't followed?
But I can hardly, I couldn't understand the whole question.
The question is, after 8/23/16, you said 6 homes were built, correct?
No, after that, 2 homes were built on that side of the street.
On the whole area. It was 8 homes altogether, correct?
There's 8 homes total on, inside of that
Okay.
private easement.
I will go to the other one. Let's talk
Okay,
about
yeah,
this
4
4
lots
here
on
that
each
you
side.
have. So 2 of them were built, 2 were not built. The other 2 that were built after 8/23/16. And this page 2 has exactly that language. And I take it that the other 4 homes on the rest of the exhibits will have the same thing. Why wasn't that language followed? It says expressly here, sidewalk.
Again, the conversation I had with Mr. Mastrasio, basically, from what I understood and took from that meeting, was that was waived. I also brought with me is the approved site plans for those 2 homes that are complete on that side of the street. Those site plans that were approved by the building department, by planning and zoning, and all departments within the city do not show any sidewalks. So as the builder of record for those 2 homes, I don't have a sidewalk on the site plan. I don't put a sidewalk on their property.
And why is this document then recorded? What is the purpose of it?
I couldn't tell you.
I'm sorry? Why was this document recorded if you don't pay attention to this and you pay attention to the subsequent document?
Again, that document, I believe, was, is accepted and recorded, and with conversations from city officials, we move forward, and I don't know.
Thank you.
Yes.
Further questions from my left? Right? Anybody in the audience wishes to speak? Yes, sir, please.
My name's Doug Bischoff, 77 Innes Drive, probably the first house to get done there besides Mr. Matthews. I purchased the property back in 2015,
I'm
October.
not, could you move the mics up a little
Okay,
bit or see
I'll
if they
bend down a little bit.
bend down?
I purchased the properties in 2015, or my property. There wasn't any time during the whole time I've owned the property that I was ever told about a sidewalk. I never made it in my plan for landscaping or for sprinklers or anything. I'm just a resident there. I don't know much about all these rules and things. I'm not in planning. I'm not in that. I'm not an airline pilot. I don't get on the plane and tell people how to fly. I just get on it and go, and sort of have to rely on you guys to do this for me. So until May of 2018, I knew nothing about any sidewalk, never planned to have one, never heard anything about it. The main issue with me is liability, just like I'm just repeating what everyone else said. To have a sidewalk go through my private property is really odd to me. It's beyond me to think that I've got to do that. I've got many properties, never had one like that before. I think that's about it. I don't have much to say. I kind of rely on the city and on the developer, to do the right thing as I'm, going along with this project. It's not easy for, a resident to build these days, or a developer. But that's all I got to say.
Question?
Yeah, I have a question for you. And I haven't put 2 and 2 together yet. So, when was the 6-foot border around the back? When was that constructed? Was that before or after you were a homeowner there?
It was before we built.
Okay.
And that was, what Mr. Matthews says is the same thing I understood, is that, oh, we don't need to do sidewalks, we're gonna do one along the seawall. Again, I'm not a developer, I don't,
So before
city
you purchased the
planner.
property, there was a discussion that that's our sidewalk? And that's qualifying as the
that was my
sidewalk?
understanding of it, yeah.
And I understand you're certainly in a predicament as a homeowner.
Yeah.
Understand. I don't pilot the planes either. But, we do talk about the liability. Isn't the liability of the 6-foot rear seawall / sidewalk a bit
Yeah, there's a liability.
dicier than a sidewalk in the front of your house?
I wouldn't say
than
so.
something
Somebody
on the
would have
water?
to cross my property to get to the back, to do that. Now, as far as what they would do right now, I think if we had to put one in the front, and if you ever go down there, you'll see there are existing sidewalks that kind of come up, and then we would be attaching to those. How would the public know that all of a sudden, unless we put a big sign there and I put a gate across it, that you're not supposed to cross and go into private land? I can put a sign there, but if nobody in the private property wants it, why do we need to put it there? It may be simple what I'm saying, and I know there's a lot of rules around this, but just as a resident that's done other things in his life besides development, it seems odd to have the city require me to put a public sidewalk through my private property. I have 15 properties or more, and none of them have ever been asked for me to do that.
Do you still own all 15 properties, or did you sell some of them, or all?
Well, I probably have 7 now.
Okay. So, but what we're talking about with a waiver attaches whatever waiver or adjustment to that property forever. So it's not you and it's not the other people that are owning it. It's in perpetuity that these people aren't going to be required to do that. And who's to say, and you could make up anything about, maybe your neighbor wants to walk their dog on the sidewalk or has a disadvantaged child that needs, wheelchair access or something along that to just go out and walk or something like that. The other gentleman talked about community and things like that, and putting something down right now as a waiver sits on that property forever. It's not just for your house. It's for that property forever.
I think the big thing with me is liability. All these things make sense, what you say makes sense to me, but liability is a big issue in America, and I had someone's dog come over and bite a tenant from the neighbor's house, and they tried to sue us. It's like, I don't know, I'm not an attorney, I don't understand it, but I know if somebody was walking across my property and their kid broke his collarbone, hit my mailbox or something, they're not going to go after the city. They're going to look at, oh, here's a guy with $1 million home, or this guy here with $2 million home, and see what they can do for us. So that's the thing. Liability is number one by many times over anything else. Yeah, it would be nice in the future. I can't tell what someone's going to want later, but to have a nice street, you can walk on the street just as easily as a sidewalk. I don't know. It's there's not a lot of cars there, a lot of traffic, so it's, a road, a nicely paved road or something would be fine for somebody on a bike or on a stroller or something like that.
All right, let me cut you off there if I can. We're starting to repeat ourselves. Any other people in the audience wishing to speak on this item? Okay. Any further questions of this applicant?
I did want to just put a point in, and just correct me if I'm wrong, liability is financial.
Yeah.
We as a board are not supposed to consider any sort of financial hardship. I'm just letting you know. I don't want you to,
Well,
I'm just letting you know that is one of the criteria that we're not allowed to consider. So when you bring that up to us, I just want you to know that we're not allowed to consider that at all.
well, I'm sure there's other things to consider, but to me, like I said, I'm not a board member, I'm not a city planner, I'm not an attorney. But for me as a resident that pays taxes here and all that stuff, I don't want the city telling me I got to let people walk across my property and then wonder if one day I'm going to have an issue with that.
And we understand
Whether that's a liability thing or just the fact that I don't want to deal with it later. I'd rather deal with it now and not have to do it. There wasn't one time in the 3 years I've owned that property that the sidewalk issue came up until May 5th or so, when I got a violation saying that if I don't put a sidewalk, I'll be fined. That's the first time I heard about it.
And I feel for you, I understand, but Mr. Matthews was made aware of it by staff back in July 9th, 2015.
Yeah.
And at that time, I didn't ask that question of him, but I would just ask, why wasn't it taken care of then?
Like he said, Anthony told him they could do it on the seawall. There's so much paperwork and all this stuff, and they took that as what they're to do. And no one bothered us about it since, so.
Well, we would accept that, but there should have been then some sort of documentation from Anthony stamping it, saying that he's approving it, so that Mr. Matthews has something to give us.
Yeah, it would have saved us having to get someone to represent us here and a lot of problems, yeah.
Okay.
I'm not disagreeing with you, but
All right.
like I said, I just don't know.
Thank you. Mrs. Terrapini, please.
Thanks for taking your time today.
Thank you.
Excuse me.
I believe, Mr. Chairman, under your rules, I have an opportunity for rebuttal. I'll be brief. I just want to make a couple of points if I could. First of all, the verbal comments that several of you keep referring to in the TRC, that a possible waiver is completely overridden by the staff's later approval of construction plans with no sidewalk and building permits with no sidewalk. Those are written documentation. So in my opinion, that has been, and that answers, I think, Mr. Glinzer's question too. Yes, there was a condition, a catch-all, a general condition on the site plan. You have to meet the whole land development code. And we, the staff, everyone knows that the staff reviews that when you go to the next level of review. The next level of review for this project was construction plans and building permits. Now the staff is saying they erred. I don't know if they erred or not, but they approved it. The staff approved those construction plans, and they approved the building permits in writing. And you heard Mr. Bischoff's testimony today. He's been in the House for, 7 months, and first heard of a need for a sidewalk waiver on May 5th of this year. Secondly, it's not really about who, to answer I think maybe Mr. Eisner's question, it's not really about who wants a sidewalk and some future owner. What it's about is the city requiring a sidewalk to be put on private property. There's no, it's just not ever done. I mean, there's a complete difference between private property and a street, and this is private property. The last thing I would say to one of several comments is there was a reference to the easement on the plat. An easement does not require you to do anything. An easement grants the right to do whatever you call the easement, and it grants you the right to, if you wish, the owner, whoever gets that easement rights, and those are the 4 owners, the 4 lots we're talking about, it gives them the right to put in a sidewalk if they wish, a right to put utilities there, a right to cross over that through access, ingress, and egress. It does not require you to install a sidewalk or require you to install utilities. So there's a misunderstanding about what that easement is. Again, I think what happened, from what I can tell and from the testimony from Mr. Bischoff and Mr. Matthews, it appears to me the city made a decision. They found that no sidewalk was required because it was private property, and now they've decided to change their mind. It's really not fair. It's not consistent with their previous approvals, and it's certainly not consistent with your code that says if you're a private street or public street, yes, put in the sidewalks. If you're neither one of those, which is what we are, no sidewalk is required. So therefore, again, I would respectfully request approval of the sidewalk for all the properties.
Okay, thank you. I've been hanging fire for a while. I'd like to make a few comments if I could. There's been a lot of finger pointing. Coulda, woulda, shoulda. Whose fault was it? Was it the city's fault? Was it the private property developer's fault? I'd like to focus on whether the sidewalk on this particular private development is warranted or not. I've been pushing sidewalks ever since I've been in Tarpon Springs, at least on one side of the right-of-way, public right-of-way, where it's needed by the public. I don't see this as a major public walking area. It's private property. The private right-of-way is, I believe, according to the plat, says 21 feet in width. In some cases, in other cases, 24 feet. But a typical road, street, is 12-foot lanes. That's 24 feet of a street, which is in pretty bad shape to begin with right now, for the private vehicular access. Sidewalks in a general subdivision are built in public right-of-way, which is, if you're building a development with the standard streets and drainage and so forth, you have, let's say, 50 feet of public right-of-way dedicated, of which 12 feet lanes, 24 feet of roadway for the vehicles. Then there's a strip of grass for the utilities, and then there's a sidewalk. The utilities for streets, water, and sewer, water, sanitary sewer, storm sewer, water, and cable utilities. And then the sidewalk, and then private property start. I don't want to get too much into this, but if gold is discovered under a street that is owned by the private property owner adjacent to that property, the public has an easement, a right to use the property for public transportation, driving, walking, biking, whatever. But once the road is vacated, it goes typically half and half to each side. And if oil is discovered or gold is discovered underneath the street, even though the public has the right to use the surface, what's underneath is owned by the property owner, typically to the midpoint, although in some cases not to the midpoint of the right-of-way. So getting back to the issue, I see it myself as, should sidewalks be built in this property? And forgetting about whose fault it was. There's a lot of blame on both sides, and I don't want to go there if I don't have to. As I see it, it's a private subdivision. The owners don't want the sidewalk. It's not going to be used by the public. You don't put sidewalks on private property for public use. Typically, when you build a subdivision, you put the sidewalks in the public right-of-way. In certain cases in Tarpon Springs, I'm thinking of Peninsula Avenue near the high school. We've got some major, there's a gap or a gore in the subdivision descriptions, and we had to move the sidewalk to get it within the right-of-way on Peninsula Road. If you go down Peninsula Road, you see the sidewalk moves a little bit because it was initially on private property and it has to be in the public right-of-way. I don't know where I'm going with this. I would just like to focus on, should we have sidewalks in this particular subdivision? And I don't see it. However, I do have a problem with the developer or the owners not having to pay for sidewalks, and there is a particular section of the code called the Sidewalk Trust Fund, which I don't know how often it's used, but it's still on the books. I asked the staff to look at it, and I would like to see some compensation put into this fund for sidewalks that are needed by the public, like the yacht club, for example. People have to walk in the street and bike in the street in a major thoroughfare because there's no sidewalk alongside the yacht club. I recognize that this county maintains Riverside Drive, but I think we can put a sidewalk there, but it's not been there, and I think that's a problem. So we need sidewalks where they're needed. But in this location, for myself, I don't see a need for a sidewalk in this subdivision. So I've said enough, I think.
I tend to agree. We certainly don't need more pavement, especially near bodies of water. And they've already got some place for people to walk. This is a simple, common sense decision, but of course the city's got you on a technicality. But I would like to make a motion that we approve the waiver with the condition that they pay something into the sidewalk fund.
And before you make that motion, sir, I took a look at the sidewalk trust fund. I don't think that applies here for two reasons. One is because they specifically came to the Board of Adjustment in lieu of paying into the trust fund. And two, the way the code reads, and perhaps staff can back me up on this, it says contributions to sidewalk trust fund in lieu of construction shall be limited to the construction of 3 or fewer lots. And we are more than 3 here, so I don't think that applies. I think they've come here for a waiver, and I think that's it.
However, could I?
You bring a good point about the sidewalk trust fund. So our application is for 8 properties,
Yes.
correct?
8 lot. Yes.
Was the applicant aware of the sidewalk trust fund option, and instead of maybe putting in one application for our board for the waiver, could do 3 separate 332? That's math, right? For the sidewalk trust fund.
I cannot answer you if they were aware of that. I can just tell you how the way the code reads is if it's the simultaneous construction of 3 or fewer lots, I believe it's 8 at the same time. I think if you broke them up like that, it would kind of defeat the purpose of what the code is writing. Because then everyone would just break everything up into 3 or fewer.
I just didn't know if that legally was an option.
In my opinion, no.
But if it was a voluntary contribution, that's my question to the applicants. I'm thinking of a few $100s per lot, maybe from the developer or from I don't care where the money comes from, but just if that is something worth talking about, we can pursue it. If it's not, then we won't.
Would it be appropriate for us to suggest that each homeowner, not each lot, because my client owns 2 lots, so only build 1 house, each homeowner would contribute $250 to the trust fund? Would that-
Make her the motion.
Where does the $250 fee come from?
Chairman.
Figure come from? Is that something that's
The figure, the code that I believe does not apply puts a certain, it's like a multiplier that's set by resolution by Board of Commission each year. So staff would have to look at that.
And I guess I'm suggesting that as an incentive.
Ask your questions and be recognized by the board. We're getting away from that, Mr. Burris.
I have a question for you, Mr. Chairman.
Yes, sir.
Suppose 2 years down the road, one of the owners sells the house to a disabled person and needs a sidewalk for a wheelchair, otherwise she has to go in the middle of the street. Who will he or she sue at that
There's
point?
no lawsuit. He can put in a sidewalk if he wants to on private property. There's no prohibition on putting the sidewalk or a ramp to his house. I have a driveway to my house.
By the same token, the police department can drive on that street. The fire department, the sewer, from what I understand, is connected to the city. Now, whoever has that home 2 years down the road and needs, let's say the traffic on that street is tremendous, and needs a sidewalk to go with his wheel or her wheelchair, what kind of position will the city be, or who will be responsible from the 8 owners?
Well, if you want to ask the legal counsel, I have my own thoughts about that.
To answer your part question, I believe, is they were requesting a waiver from the requirement. It does run with the land. It's not a waiver. It's not something that prevents them from ever. They could decide tomorrow that they all decide, actually, let's all build a sidewalk, and they can. It's not permitting. It's only waiving the requirement, not mandating that they can never. Does that make sense?
the option's always there.
Yes, it's a waiver of the requirement, but like I said, tomorrow or 100 years, the property owner could decide to build on either collectively or individually.
Hey, Mr. Eisner?
My question goes a little further than George's. Your question is regarding the homeowner being the handicapped person. And one of my questions was, there are many people that come to people's homes, whether it's if somebody has a flood in a house, an insurance adjuster comes to the house, they can be handicapped, and they would have to be able to have access to a house.
Well, that's same in every single house in the city.
Yes, I'm aware of that.
What's the question?
My question is, do you build today, like when you're building new locations, you must make something handicapped accessible.
Public facilities and semi-private facilities have to have reasonable handicapped access, but a private home is exempt from ADA.
Okay.
Okay. So there's a motion on the floor, no second yet. But one of the applicants here has agreed to pay the $250 per house. And you would too? And I see a hand waved in the back. That's agreeable? You? And your name, please? We'll get your name later, but, all right, Mr. Matthews, would you be willing to contribute for your house or for all the houses that are not represented tonight? Just for your house? All right, so there's a figure of $250 per lot, and we're not sure whether it's legal or not. We haven't gotten that far yet, but they're agreeing to pay $250 to go to a fund to build sidewalks in the city, whether it's there, whether we have the fund or not. They could certainly make a contribution to our city manager. I'm sure he'll take the money.
Chair, I would also just advise, I'm not sure, and maybe someone could ask, I don't know if everyone here is represented tonight, and if they are represented, if that person was given the power to let them put money on their behalf.
Okay, so where are we?
We don't have a
Motion?
second yet.
Yeah, is there a
So I'll
second?
repeat my motion.
Yes.
What is your motion?
Motion is to approve the waiver with the condition that they pay some money into the sidewalk fund, and they've agreed.
What if the
Yes, sir.
owners, the rest of the owners say no?
It's a good question.
Well, you can,
And
if
I
I
think
could,
that's
you
the
can make the
problem.
motion that if they want the waiver, they have to pay
Yeah, but we have to
$250.
decide on all 8 of them.
So
We have to decide on all 8 of them.
Yes,
yeah,
that's
so
true.
we
but
put,
that's-
so we're going to
overrides
pick
it.
the 250 figure and apply that to the motion per lot, I guess.
I don't believe you can put a condition on this. That's not what they're asking for.
But they're voluntarily agreeing to waive it.
Some are.
Some are, and
We have 3 of the 8 property owners present.
Well, you have two.
4, excuse me, thank you.
but if they
Don't
don't,
you represent two?
if they don't agree to it, then maybe they won't get their waiver. I don't know.
But the application
putting a
is
condition on it.
for,
I'm sorry?
the application is for all.
Yeah, but only 4 spoke. Only 4 that are here. We have to vote on all 8, I guess.
We don't have a second.
It is one application for all 8 lots. I believe.
Hypothetically,
Glanzer? Yes.
the $250 fee times 8 is $2,000. You could make a lump sum condition
Right.
for all 8, whether or not they, and if that's a condition and one of your neighbors
Motion.
doesn't want to participate, then someone else can cover it.
I don't believe you can put a condition on this. That in certain variances, you can. This is a sidewalk waiver. And I don't believe the code is silent as to adding conditions to a sidewalk waiver.
Okay, well, appreciate your opinion, but we can still make the motion and put in that figure and,
Yep.
See what
Apply the figure and let's see what we do.
all right.
Do we get
so
a
the
second?
motion, yes, you want to? We'll call the audience, we'll give you the audience some time to speak after we get a second on the motion, because we may not get one. All right, so the motion is to grant the waiver for all 8 condition upon the payment of $2,000 to the city of Tarpon Springs. Is there a second?
To the City of Tarpon Springs Sidewalk Trust Fund.
No, it doesn't need to be to that fund, it could be to,
Well,
I
now
should
you're
I could
conditioning
make a
it
lot of
from
bad jokes, but I
No,
won't.
no, no. The sidewalk trust fund
Sidewalk
was
trust fund.
specifically my original motion. I guess there's,
Okay, is there a second? All right, I'll second the motion. Discussion? Now, Mr. Bischoff, do you want to speak? You want, at the podium, please, you got to be on the record.
while he makes his way. I mean, I have sidewalks on both sides of the street that I live on. Nobody walks on them. They walk in the middle of the street with their dog all the way because it's not a well-traveled street. This will be the same. I mean, I just don't see the logic in
Yeah, I
putting
mean, I
more
was going
pavement
to say,
down.
basically, I'd volunteer $250 just to be done with this and go home and watch TV or something. And then, what everyone else does or what's legal, I don't know. Like I said, I don't know about all that stuff, but I'm kind of ready to move on.
Thank you.
Thanks.
my,
Kind of an aside, on the corner of Riverside and Sunset, there is a house that asked for a sidewalk waiver maybe 35 years ago. The staff recommended approval and it was denied. And you, to this day, you'll see this sidewalk that goes nowhere in front of one house, for whatever benefit that may be. Mr. Eisner?
I was going to say, I didn't feel that we met the criteria, is my thing.
Yeah, well, I think the people who live there, it's a private right-of-way, not dedicated to the city, private, and the sidewalk would be on private property, not even in the private easement area, which is only 24 feet in width. Normally, it's 50 feet minimum to be in a public subdivision. It's 50 feet, I think. Is that correct, Louis? 60 feet, 50 feet?
Yeah, I believe 50 feet is
50
with
feet.
curb
This is
gutter.
24 feet, the width of 2 lanes of a thoroughfare.
And Mr. Eisner, I agree. You know, technically, if you look at it, you wouldn't have met the requirements, but Ms. Terrapini gave you something to hang your hat on. If you view it through her lens, then they meet them. That's all I can say about that.
I also have another question just for, significant, substantial type things. There's a statement in the background from the staff report saying, the fact that the staff erred by not requiring the sidewalks to be shown on the site plans for the individual lot does not relieve the applicant of the requirements of this. That to me is an opinion of the staff, and I'm wondering what ramifications that could have going forward if any of these motions are even talked about or approved. It's just, that to me seems like a pretty germane fact that I'm not necessarily convinced that there wasn't something there that did resolve or absolve the homeowners of that. Is there a legal angle on that fact?
I don't understand the question.
Sorry.
Saying there's this some estoppel language in the fact the city did not do something, and therefore there is some grounds for granting the waiver. And we're talking about a waiver, which is less of a standard than a variance. I want to make sure we're all clear on that. There's no hardship requirement in a waiver.
Correct.
Just is it unreasonable or unwarranted is what the language used to state in the sidewalk waiver provision. The language in the plat, by the way, for the, various uses of the easement area, that's just standard boilerplate language for the streets, drainage, sidewalks, and so forth. You can't hang your hat on the fact that, well, it says you can put a sidewalk in here. It doesn't mean you have to put a sidewalk in here. I concur with the applicant's representative on that. All right, so there's a motion and a second. Any further discussion? Seeing, hearing none, let's have a roll call, please.
Ms. Turner?
Deny.
Mr. Eisner?
Deny.
Mr. Burris?
Denied.
Mr. Urbowski?
Yes.
Mr. Elliott?
Yes. Okay, motion dies. So is there another motion?
I make a motion to deny.
I will second it.
Okay, that's all 8 now, and require the sidewalk.
As applied.
And that's was it a 4-foot sidewalk on each side of the street? Is that what we're talking about, Luis? The standard is 4 feet on both sides, on each side?
Why both sides?
Let me double check that. I believe
the
that's
code-
correct. It's 4 feet on both sides, but let me verify that. Good.
While he's looking at that, can I ask the developer a question about the street construction? Are you planning on redoing the street? Or is someone going to redo the street at some point?
It was our intention that once construction of the homes were complete, I would be repaving basically put a 1-inch top coat of asphalt on. The homeowners have decided, as a majority, that in lieu of doing the asphalt, they want to do a clay brick paver
24 feet in width?
onto the existing. There's actually a Miami curb on both sides of the street right now. So
2 feet in width? Miami curb is 2 feet?
I'm going to say it's about 18 inches. I don't believe
But,
it's a
so
full
it's
2
less
foot.
than,
Yep.
so like 18 feet of pavement,
Yes.
new pavement, and then the 2 foot of open, of the
Yes.
curbing? Okay. Any questions, any answers there?
I wanted to put out there also, you had, Mr. Chairman, you had asked me if, as a developer, would I be interested in just writing a single check for the development? If it puts this to rest, I'll do that.
Okay. Mr. Cerna?
It is 4 feet on both sides of the road.
Okay, so the requirement of the code is 4 feet on both sides of this 8-foot, eight lot subdivision. Is that what your motion is? To deny the variance?
The waiver.
And they got to put in,
Deny the waiver.
so they have to put in
As written.
8 foot of sidewalk, 4 feet on each side. Okay, we got a motion, a second. Any further discussion?
No, we had
We
two
need a
votes.
second.
Didn't we
There was a
have votes?
motion. Is there, and we do have
You
a
made
second.
the
Excuse me.
motion is-
Sorry, sir.
Didn't you vote on that?
Discussion of the motion.
I made a motion and you seconded,
Right.
and then we've had discussion.
Okay, now we're ready to vote on the motion. All right, let's have a vote, please, Kim.
So this is
You
the
did
motion
vote.
to deny. So if you want it for deny, you vote yes. So it's a negative motion.
With no conditions?
No conditions.
Ms. Turner,
Yes.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mr. Urbowski,
No.
Mr. Elliott.
No. Okay, being the chair, the motion to deny has been passed, so I guess that ends the discussion. Thank you all for your patience.
Thank you.
Next on the agenda is the approval of our July 25th minutes. Any comments on the minutes? I was not present. My compliments to the chairman at that time.
That was George.
Yeah.
I'm allowed to learn.
You rocked it.
Is there a motion to approve the minutes of that meeting?
Motion to approve.
Second,
I'll second.
discussion, all in favor? Aye.
Aye.
Number 6, staff comments.
I have no comment.
Legal department? Any
No comments.
Yeah. Number 7, board comments. Could I make a comment about the meeting in June?
I had comments I wanted to make. I've spoken to, I've spoken to Tom Trask, and I had asked if it was okay to have a further lessons and classes, because that was originally allotted to us by the mayor, and we never had that.
Classes for what?
Well, there are situations that I was, maybe you're aware of, but I wasn't aware of, that, like a case like this or any of the cases, that we're not allowed to be discussing them for 30 days because of appeal. They can't appeal, so there were, am I correct in that, that we're not allowed to discuss the cases?
It's best practice not to.
Right. So there,
I think you're like the review of Sunshine.
right.
Yes.
That's, so there were other things that I thought that we should be made aware of, just not to err. But
It's a good idea.
whenever we can have that. I mean, we do have also, and I won't single you out, but we have 2 new people on the board, and I'm,
out.
well, because listen, I didn't know that either, so
Yeah.
I'll include myself in there. I'll throw myself under the bus. But it's helpful, to make you a stronger board member, that's all.
No, I strongly agree with that. I studied Sunshine in college and have worked in public entities in the state, so I'm familiar on that end, but I do feel particularly in our roles here, that it is a vital knowledge base for us to gain.
So what do we do? So someone's going to make a request?
Chair, I do know that Heather has been in contact with our office to develop some type of presentation for all of the city's boards to address quasi-judicial procedure, sunshine law, public records, all of that. So our offices have been in contact, and we're moving forward on that.
Thank you.
Thank you.
You know, case in point, I like I said, I had no idea, you know, being my, and I do want to speak about this because I made the announcement about my ex parte communication. I was instructed not to take the call and just make the hang up and, you know, say, sorry, I can't speak of that and just end it there. You know, of course, I thought that if I said nothing particular to the case, that was allowed. And it's not. So, you know, you do need to, you know, I would like to hear more about what I should and shouldn't do. So,
Yeah, I would agree because I'm still not sure of the actual legal ramifications of a staff error.
right.
If there's a staff error, what does that really mean legally? Can we consider that? Can we not consider that? Is that substantial significant? If there is an agreement that the staff made an error in something,
In general, I do want to explain something. All of the permits that go through the city here, the engineer that looks over the plans and approves the plans clearly states on it that he or she is not responsible for any errors that they've made. I'm just saying it, on the plans. So it all falls always on the builder, developer, whomever. So they could actually completely ignore something, not include something, and there's no bearing on the staff.
well, and you know, we can talk about sunshine law and everything, but I know I was never trained in what the conditions actually, I was never instructed as to, you know, putting a condition in what, if it's standard boilerplate that you're supposed to cover any other thing. Okay, this would be on any other thing. Should that be considered or not considered as significant, substantial? Did that number one condition, was that legally a catch-all? And you can call it a catch-all, but that's what catch-alls do, is they catch everything. So I don't know. And I didn't feel, and not that I had to vote, but I didn't feel that I had enough wisdom on those couple of points to actually make, I'm glad I didn't have to vote.
Okay.
It was asked of me to ask the chairman, so I'm asking you to.
Contact the staff, the mayor, the city attorney?
No, just to move forward with that so that we can have, whether, he said that it was probably best to not make another date, that when we have a quick meeting, that we can maybe just extend it another half hour, whatever it's going to take to go through whatever we need to do.
Well, what's happened in the past is the city attorney staff has had a meeting for all the board members of all the boards and have all these questions are addressed at one time, as that's what's going to happen this time, I think.
That's the hope.
Wonderful.
Can I make a comment about the June meeting? My vote, I want to elaborate a little bit about what I said. This is the Lanai vote. We went back and forth several times. Remember?
Was this the one that was the two houses? There were two different
Yeah, one was
applicants.
withdrawn.
One was withdrawn.
Bayshore Heights?
Yeah,
Whatever.
it was Bayshore Heights,
Okay.
yes.
Right, okay. Thank you for,
I just want the minutes to reflect that it was a very tough decision for this board. There were, I think, 4 votes on this one item. The first time there was a motion and there was no motion. And then the second time there was a motion to deny and there was no motion. We couldn't decide what to do. When it came up for a rehearing, we had some difficulty. And there was some fault on the part of the staff. And the board passed a motion to grant the variance. It was 3-2 vote finally. And I was concerned that other people in the subdivision might want to try to piggyback on this one variance and say, well, somebody got the variance to put in a lanai, a covered lanai, I think. why can't I, the Me Too thing. And the facts of that case were very different from the usual situation. We had a lot of trouble struggling with it. And just want the people in that subdivision and the minutes to reflect that any future requests from the developer said they would not apply for any more lanais, but the private property owners, of course, can always apply for a variance. But those will have to go to the city commission for approval. That this is a policy decision on the part of the city commission. If they want to put in more lanais, it's not going to be and my suggestion is it would not be for a variance. It has to go for a change to the ordinances because of the unique situation in that case.
But it's also known that we don't use any prior cases to decide future cases.
Yeah, I know, but we have this constitutional provision called equal protection, and if someone comes in and says, "Hey, my neighbor got a lanai, why can't I?" and they have to prove unique situation, and they just say, "I want a lanai because I have family coming to visit." That's not enough. What was different in that case were the unique facts that we had some trouble with, and we decided to grant the variance. I don't know if I meant anything.
It was also sold with it, and the builder found out afterwards that he wasn't allowed to do that.
There was some staff, again, talking about the estoppel, the detrimental reliance. There was some city approvals for that lanai in a different house. And the developer said, well, they got a lanai over there. We can put one in here. And all of a sudden, we realized our mistake, the staff did, and the decision was made.
So were those mistakes on those that you were referencing? Because I know ours were due to the setback, the unique nature of the size of the house and everything. Because all those houses in that development have lanais. It was just a matter of.
I don't know. Do they? I don't think so.
Covered lanais, yes, they do.
They do?
Yeah.
Oh.
But also, they were also giving that there was a huge, like a water pond back behind there. There was a lot of space behind
Retention
there.
pond.
Retention pond, thank you. So there was extenuating circumstances that particular case wouldn't be available for others.
That the developer will build, not the private individuals that may have a house already and do not have a lanai.
But they can ask anything they want.
But they
They can
weren't
come-
putting, the developer rescinded all future plans for that particular
The
blueprint.
developer did, but there's a lot of houses that are previously built, and I don't want,
But I thought, I was under the impression that all the other ones were in compliance already.
Correct.
they can ask for lanai, a setback variance to.
Well, that would be a whole, that's what you're saying, it's a whole
Yeah,
separate thing.
that
Yeah.
whole, this is a unique case, and the people in the future, if they want to try for it,
No.
I'm going to say it's a different set of facts than what we had suffered through with those 4 or 5 votes. Maybe I made things more
Affectionately known as the
complicated than I should have, but
Cleanser flip, I think.
it's been bugging me for a couple of months, so.
Yeah, I remember that.
I'm glad
All
you
right.
have that off your chest.
Okay, thank you. Now I could sleep easy, and it's meeting adjourned then at 8:45. Thank you.
How's the house coming along?